This is TWiT.
We have had some movement in that Supreme Court ruling regarding Texas's social media law. Joining us today is a familiar face and a very learned individual when it comes to law and tech. It is Denise Howell. Welcome back, Denise.
Hi, Mikah. It's so good to see you.
It is excellent to see you too, and so glad we got to get you on the show today to talk about this. So I think it would be best if we start things off by sort of rewinding history a little bit and talking about this Texas social media law. Where did it come from? What's it about? Before we get into the Supreme Court's ruling.
Yeah, that makes perfect sense. And rewinding even further, or taking it out, perspective-wise even further, Texas is not alone in wanting to enact a law similar to this. What the law does, so that we know what we're talking about. Oh, I'm so sorry. I meant to silence the phone. There it goes. What the law does is give the state the authority, or the purported authority, to tell social media companies that they can't moderate their content. It also, the Texas one threw in an interesting twist in that it also didn't want email providers to be able to filter spam, which I think we all know how we feel about that one. But the more thorny issue of whether or not social media providers are overstepping their bounds in deciding how to moderate their content is really what's at the crux of this law. There was another one in Florida earlier this year, very similar. And also the states of Georgia, Ohio, Tennessee, and Michigan are considering similar laws. So we're not just looking at a lone isolated case in Texas. We're looking at sort of a movement. And the basis of the movement is this sense that social media companies are infringing people's free speech, which is a very interesting concept in its own right, because the way our free speech laws work, the way the First Amendment works in the United States, is private entities really can't, under the law, do anything that impacts the First Amendment in their decisions to moderate or decide editorially what's going to be on their site. Only the government can. The First Amendment actually says the government shall make no law, Congress shall make no law that impacts people's speech or limits people's free speech. So that's where this all sort of sits, is despite the fact that the First Amendment works a little differently than you would think this Texas state law thinks it does, Texas and these various other states have decided we're going to enact these sweeping laws that require social media companies who are doing business with the residents of our states not to take down, in the Texas law's case, it was take down items on the basis of their viewpoint, which, as you can imagine, is a big, sweeping, open to interpretation kind of bit of language there. There are some limitations on it. If things were illegal, there's some very narrow exceptions laid out in the law that give sites the ability to take down things that would otherwise be illegal, basically. But other than that, if something is inaccurate, if something involves hate speech, which in itself isn't illegal, hate speech plus a threat of actual harm is. So there's a bunch of things that sites are doing to make their platforms more the place they want to provide for users, more the environment they want to provide for users. And these laws would say, nope, you have to treat content much more neutrally. It doesn't matter if you think it's inaccurate. It doesn't matter if you think it's offensive. It doesn't matter if it's against your guidelines for user interactions. If you're moderating on the basis of someone's viewpoint, says this Texas law, you can't do it. So that's what the Texas legislature enacted, and the Governor Abbott there signed into law. So since that happened, this also followed a similar procedural path in Florida earlier this year when it enacted a similar law. Someone filed a lawsuit challenging the constitutionality of the law. The someone in this case being a trade association of tech companies with tech company members. So there, in both states, there were lawsuits pending that said, hey, these laws are unconstitutional. They should be repealed. And what we saw the Supreme Court do this week on the 31st was intervene, because the way procedurally, the way our system works is basically 3 tiers, oftentimes at the state and definitely at the federal level. You've got a trial court where a lawsuit is filed. And then you've got this intermediate level of appellate courts in the federal system. They're called circuit courts. And different circuit courts look after different parts of the country. And then above them all is the U.S. Supreme Court. So the way that the U.S. Supreme Court generally takes cases, it doesn't take every case it's asked to take. And it didn't take this case, importantly. All it did was it was asked to, it someday may well take this case, but that's not what happened here. What happened here is the intermediate appellate court got involved. That would be the Fifth Circuit that looks after Texas. It got involved when the trial court there took a look at this. There were motions filed in the case that was moving on toward trial. Wouldn't have been a jury trial. All that's at stake here are legal issues of constitutionality of the law. So juries don't get involved in that kind of thing. That's strictly up to the judge to decide. So the plaintiffs in this case, the Trade Association of Tech Companies, expedited things a bit by, this case will still go to trial, but they moved in early and said, hey, we would like you to issue, trial court, a preliminary injunction, which is basically a stay of the law. The law would have gone into effect, but I believe it did actually go into effect briefly. Mm-hmm. But the trial court said, hold your horses here. We're going to take a look at this. The standard on granting a preliminary injunction is really, really high. So what the trial court had to be shown was that the plaintiffs had a likelihood of success on the merits. That means when they get to trial, the trial court has to assess everything and see, are they likely to win? And here the trial court said, yeah, they're likely to win. They're likely to win on all these constitutional challenges. And there's a second part that has to be in place too in order for the trial court to do what it did. And that is, if we don't grant this injunction now, what happens? Is there irreparable harm by this law going into effect? So that's where the trial court had to get into the constitutional analysis and decide, if we go ahead and say that Texas can control the social media platforms in this way and control their private company decision-making, what does that mean? Well, what the trial court found was that means it improperly impairs the First Amendment rights of those companies, which a lot of people don't know that private companies, although they have lesser First Amendment rights than individuals, they do have free speech rights. And there are cases on the books, several Supreme Court cases, that talk about how editorial decisions by a private entity are protected under the First Amendment. So that's what the trial court did. It put an injunction in place. The Fifth Circuit then, its intermediate appellate level, got involved and was asked to decide, should this injunction be in place or should the law take effect while this case goes on to trial and then these constitutional issues are decided there? The Fifth Circuit seemed a little confused. The Fifth Circuit issued a very short order, but at the hearing on this matter, a lot of the justices were taught. They're judges at that level, not justices, and there's a 3-judge panel that makes that decision. And a lot of the dialogue there tipped their hand that the way that they're considering social media platforms is as common carriers, like your phone company, like a network on television. So when you're a common carrier, you have various responsibilities to be content neutral. And again, networks on television don't even really fall into that category. A telephone company is about the best example you can give. Networks on television obviously exercise editorial control. But when you place a phone call, nobody's going to be listening in and going, hey, I see that you're plotting to rob a bank or whatever, and we're going to immediately terminate your call and terminate your account. And, unless you're being monitored by the government, that doesn't happen. So a lot of the Fifth Circuit judges seemed to be confused as to the actual nature, the legal status nature of social media platforms. And that's how they got to their decision, one must assume, that the law should go into effect while this constitutional challenge is pending. So what that means is cases typically take months, if not, a year or two to get to trial. And that would mean that for that period of time, this law would go into effect and social media platforms would have to scramble to comply. So here's what the Supreme Court did this week. The Fifth Circuit's decision was challenged to the Supreme Court, and the Supreme Court justice who looks over the Fifth Circuit's decisions is Justice Alito. Mm-hmm. And what Justice Alito decided to do is, the challenge was, did the Fifth Circuit do the right thing here? The Supreme Court was not asked to decide anything constitutional on the merits of this case. All it was asked to decide is, should this law go into effect or not? The trial court said, yes, we should stay this law. It granted a motion for injunction, said it should be enjoined. Then we'll get to the constitutional issues at trial. And if people want to appeal that up the chain, they can do it then. Fifth Circuit said, nope, let's go ahead, let it go into effect. Supreme Court decided in something called the shadow docket, which sounds very clandestine and cloak and dagger, but all it really means is they don't have to lay out the basis for their decision. All they have to do is say, yeah, we agree, no, we don't agree, this is a procedural issue. And I think, in most instances, what you would expect the court to do is take a pretty hands-off approach to the circuit court's decisions that are presented up to it. But this was a little unusual. It was unusual in two ways, or maybe several ways. First, Alito didn't make the decision on his own, which he is authorized to do. Instead, he referred the outcome, should this Fifth Circuit undoing of the injunction stand. He referred that to the whole Supreme Court to decide. So they get to have, every justice weigh in on that issue. And they did. And the majority of the court went ahead and decided, hey, you know what? The trial court here has some discretion to make this decision of law on its own. There may be a time, again, this is all just reading between the lines because on the shadow docket, the court doesn't issue an actual opinion. They just decide, should the Fifth Circuit's decision stand or not? And here they decided, no, it should not. What should stand is the trial court's injunction. That means the law is on hold until there's a trial and a final determination of the constitutionality.
So,
yes.
So does that mean that we could see, if you had a prediction of when we could see this this trial go through, at what point? I mean, is that something that we'll be looking at later this year? Is that something where we're kind of seeing how other states are responding to this and then moving forward? What are your thoughts on kind of the future of this now that it's on hold?
So it's on hold per the Supreme Court. There was a dissent. So we know that certain justices, including Justice Alito, would have liked to see this law go into effect while the trial court case is still pending. So they actually wrote a dissent. That was Justice Alito, Justice Thomas, and Justice Gorsuch. All thought, yeah, let's go ahead and let this go into law. And they explained why they thought that would be a good idea. And they were much more charitable to the Fifth Circuit's reasoning, which is a little questionable. So they're kind of tipping their hand, I believe, if this eventually comes up to the Supreme Court, how they would be inclined to rule on the constitutionality of the law itself. Justice Kagan, interestingly, also wanted to see the law go into effect, but she didn't join the dissent, which means she doesn't agree with the reasoning of the dissent, but she agrees with the outcome. She, for whatever reason, nobody's asked her, and she's not saying, she would like to see it go into effect too. But the rest of the court, which is Chief Justice Roberts, Justice Kavanaugh, and Justice Barrett, tellingly on the conservative side, all voted to go ahead and let this injunction stay in place. So back to your question, how long, are we looking at it being in place? I'm pretty sure, given what's happened here, it'll be in place until a final decision comes. Now, what's a final decision? The trial court will make a decision at the trial. How long will it get to trial? Several months, possibly a year, possibly more. I mean, it depends. I would think that they would want to expedite this. I would think that because these are primarily questions of law that don't require a whole lot of evidence to determine that it could be expedited. There wouldn't be that much discovery. But again, who knows? Someone may want to lay out a whole bunch of real world scenarios of things that have happened with respect to moderation and present those to the court. So we'll just have to wait and see how long it takes the trial court to get around to its decision. But then once we have a decision on the merits from the trial court, which we're pretty sure is going to be that the law is unconstitutional because of the way that they have ruled on the injunction, which had a really high standard of deciding whether the plaintiffs were likely to succeed, then we'll see it go up to the Fifth Circuit. We're pretty sure we know what the Fifth Circuit will do since they kind of tipped their hand in undoing the injunction. And then it would go up to the Supreme Court. But I'm pretty sure that a stay will stay in place until we get a final decision from the highest court. The Supreme Court doesn't have to take this. It doesn't have to take any case that it's presented with. But this seems like an important enough issue with enough controversy in enough jurisdictions in the country that it probably would take this case.
Yeah, that makes sense. That makes sense. Well, Denise Howell, I want to thank you so much for spending some time out of your day to join us here and explain this. Particularly, I think it was a great moment where you talked about how those court systems work. And I was taken all the way back to, I think, 6th grade where I learned that. It's been so long that, I have not remembered from that point kind of how those court systems work from the ground up. And so that was very helpful. You've done an excellent job explaining everything today. And I want to thank you. If folks want to follow you online and check out all the great work that you do, where should they go to do so?
I'm D. Howell on Twitter, and my website is denisehowell.info, and everything you need to know about me is there.
Awesome. Thank you, Denise. We appreciate it.
Thank you so much, Mikah. Have a great week.